You're now the attorney-in-fact for the state name.
No, sir, Mr. Thompson, you know I don't put up with any of that. You understand?
Right.
Listen to me.
Yes, sir. Go ahead.
You understand I'm not going to put up with that?
Yes, sir.
Not anything like that. You understand? Do you understand me?
Yes.
There's not going to be any private citizen, sovereign citizen, any of that. You understand?
Yes, sir.
Okay.
Before we even get into today's courtroom chaos, let me set the stage, because this isn't just another routine docket. This is Florida. This is probation court. And this is Judge Brantley Clark, a judge who has built a reputation for having exactly zero patience for courtroom theatrics, pseudo-legal nonsense, or so-called sovereign citizens who think saying the right magic words makes the law disappear. Today's video features not one, not two, but 4 separate appearances where defendants try every trick in the book, refusing to identify themselves, inventing legal loopholes, and clinging to internet law myths that collapse the second they hit real courtrooms. You're going to see probation violations, warrant confusion, self-representation gone wrong, and one of the most spectacular examples of a defendant confidently misunderstanding the law, while still somehow believing he's the smartest person in the room. Pay close attention, because Judge Clark walks a tightrope here, firm but fair, sharp but controlled. And in one moment, he almost slips, a mistake that could have changed everything. Stick around, because every minute of this case escalates, and by the end, you'll see exactly why trying to outsmart the system often does the opposite.
Before the court today for your affidavit of violation of probation, you filed a bunch of stuff that doesn't make any sense. I've denied most of it. I'm going to probably deny the rest of it.
Really?
Yes, sir.
All right.
Absolutely.
I got some education to go, huh?
Sir?
So I've got some education to go.
Yes, sir. You're here today by, you got a new law violation of driving my license, suspended, or revoked. You don't want to have an attorney appointed to represent you?
No, sir.
Are you sure?
But that's the thing is, I've never even been pulled over. I don't know how I got a license or a warrant or anything. If haven't been pulled over in more than a year, any emergency contact. I went to go pick up a records request and they gave me a warrant instead of the records.
Do y'all know anything about this?
As to the new law.
Do you have a driver's license?
No, sir.
Don't answer that. I shouldn't ask that question.
Fair enough. Fair enough.
Strike that from the record. I won't do that if you won't do any other mess. I won't ask you that question.
Right here is where Judge Clark draws the line, and he doesn't do it gently. This isn't just a judge flexing authority. This is a judge who has seen this exact routine play out dozens, if not hundreds, of times. The private citizen argument, the refusal to recognize the court, the pseudo-legal jargon, none of it is new, and none of it is impressive. What's important is how quickly Judge Clark establishes control. He doesn't debate. He doesn't entertain hypotheticals. He shuts it down immediately, making it crystal clear that this courtroom operates under real law, not internet forums. This kind of firmness is crucial, especially in cases involving probation, where defendants often believe technicalities can save them. By setting expectations early, the judge prevents the hearing from derailing into nonsense, and that discipline is going to matter later, especially when defendants start contradicting themselves.
But you transfer that to
Just filed. I just filed in the court file.
I tried to and they wouldn't accept it.
All right. Was he arrested? Is there a new arrest for driving license, suspended, or revoked? State?
Yes, there was a bench warrant issued on 1/23/24 that's executed 1/29/24.
Said I was just doing a records request and had an agreed upon date to pick it up, went up there to pick it up and gave me a warrant, so the records are requested.
What I'm gonna let y'all
Return
do
that?
Listen, I'm gonna leave him on probation. I'm gonna set this for preliminary on April. What's that April date?
April 17th.
April 17th. I'm gonna let him take care of that in county court and see what happens. Okay?
Thank you.
And I think that's the only violation he had.
Yes, sir.
Keep doing what you're doing on this, and then we'll see you back in April, and you can take care of that in county court. Okay?
Right, thank you.
Yes, sir. Sign a notice.
This moment is subtle, but legally massive. Judge Clark almost asked a question that could have handed the defendant a golden ticket out of consequences. Had the defendant admitted on the record that he was driving without a license, that statement could have been used against him, but if it was improperly elicited, it also could have opened the door to suppressing evidence or challenging a conviction. The judge catches himself just in time and immediately strikes the question. That's not weakness, that's professionalism. Even experienced judges can slip, but the ability to self-correct in real time protects the integrity of the case. Ironically, the defendant has no idea how close he came to benefiting from the judge's mistake. And that's a recurring theme here, people loudly claiming the system is rigged against them, while completely missing the moments where the system actually protects them.
State your name, sir.
The beneficiary, Cedric Alexander, a human being.
Mr. Alexander, I don't accept any of that. If you want to state your name, state your name. If you don't, that's fine.
I'm Cedric Alexander, the beneficiary, sir.
No, sir, I don't, the beneficiary doesn't mean anything to me, says, are you Cedric Alexander?
I'm a human being, Cedric Alexander, not the corporation.
What be hell with that?
I'm a human being, not a fictitious entity.
On your first appearance, I'm going to appoint the Office of Public Defender. You've got a failure to appear on
Not your majesty, my public
misdemeanors.
defender.
I have ordered to be held without bond on that. I'm going to leave that as it is. You got a possession of methamphetamine and see, that might be all the same thing. Yeah. You just got a failure to appear.
The officer didn't even come and do
You'll be
deposition
held
because it's a
without
lie.
bond on that. You got a drive my license, suspended or vote. I'm gonna find there's probable cause. I'm gonna set. That's a third degree felony, punished for 5 years, Florida Department of Corrections, and a
Fictitious entity cannot drive,
$5,000.
sir.
I am going to set a $5,000 bond. I'll see you March 11th at 9 o'clock. Good luck.
Thank you, sir.
All right, go ahead and step out for me.
This is where a lot of viewers misunderstand what's happening. Judge Clark isn't letting him off. He's exercising judicial restraint. Probation violations can result in immediate jail time, but judges often prefer to let underlying charges be resolved first, especially when county court outcomes could directly affect sentencing. By keeping him on probation and setting a future date, Judge Clark is giving the defendant rope, not freedom. What the defendant does with that rope is entirely up to him. This is a calculated decision rooted in fairness, not sympathy. And it also puts the responsibility squarely back on the defendant: fix your mess, follow the rules, or face the consequences later. It's the kind of judicial patience that sovereign-style defendants often mistake for weakness.
Preliminary adversarial hearing, you're representing yourself. You know, at any point in time, you can ask an attorney to be appointed to represent you. Do you understand?
Yes, sir.
Do you still wish to represent yourself?
Yes, sir.
Yes, sir.
All right. Mr. Loving, you can call your first witness.
Your Honor, the state calls Officer Zip. Richard Zip.
Just swear the witness in.
Promise for the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God.
I do.
Can you state your name for the record, please?
Richard Ziff,
Where are you employed?
Panel City Police Department.
Were you working in November of 2023?
I was.
On November 11th, 2023, did you have occasion to come in contact with defendant Josiah Beecham?
I was.
How did you come in contact with him?
It was an investigative stop. Mr. Beecham's vehicle was having a hard time maintaining its lane. I conducted a traffic stop on the vehicle. Vehicle drove over the curb. Immediately when I stopped the vehicle, I can smell marijuana coming from within the vehicle while still sitting inside my own vehicle. As I got closer to the vehicle, I can smell the marijuana getting stronger. When I made contact with Mr. Beecham in the driver's seat, I informed him the nature of the stop, also told him I smelled marijuana in the vehicle. At that point, Mr. Beecham was saying I was violating the Treaty of Florida, making other statements that he was not driving, he was traveling.
This is the shortest hearing, but it's one of the most revealing. When a defendant refuses to identify themselves, the court doesn't panic, it proceeds. Identity isn't optional. Courts don't negotiate reality. Judge Clark makes it clear, either you participate in the process, or the process moves forward without your cooperation, and usually not in your favor. The irony here is brutal. By trying to avoid accountability through wordplay, the defendant guarantees it instead. There's no dramatic speech, no argument, no debate, just swift action. And that's exactly why these tactics fail. Courts are built on procedure, not performance. The moment you refuse to engage, you lose control of the outcome.
And at one point, I asked him to identify himself. He refused to identify himself. He began to call 911 and requested a Bay County deputy respond to the scene because he refused to cooperate with me.
Officer Zip, at some point, based on the smell of marijuana, did you search the vehicle and Mr. Beecham's person?
I did.
During that search, did you locate anything of note, of significance?
We found trafficking amounts of controlled substances. I believe we were, one of them tested positive for cocaine. There was marijuana and we believe fentanyl.
Did you find any firearms during the search?
There was a firearm located underneath the driver's seat that Mr. Beecham was sitting on.
This is where internet law myths meet reality at full speed. The Treaty of Florida is a real historical document, but it has absolutely nothing to do with traffic stops, marijuana odor, or a supposed right to ignore police authority. Sovereign citizens often weaponize real legal terms stripped of context, hoping volume replaces validity. Officer testimony here is clean, consistent, and methodical. Lane drifting, odor of marijuana, refusal to cooperate, all legally sufficient grounds for the stop and search. The defendant's confidence doesn't make his argument stronger, it makes his misunderstanding more obvious. Courts don't care how passionately someone believes something, only whether it's supported by law and evidence. And here, the evidence stacks up fast.
Did you run a criminal records check on Mr. Beecham?
We did.
Did you find out whether he had been previously convicted of any felonies?
He was on inmate release status for a felony. I believe the same charges.
No, that's all my questions at this time.
Mr. Beecham, any questions?
Yes. So did I have a passenger in the car with me at the time?
You did?
Upon you saying you smelled the smell of marijuana, did I say that I smoked hemp?
You did admit to it.
I said I smoked hemp, right?
You said you smoked marijuana.
Sir, did you have on a body cam?
I did.
And okay, thank you, Your Honor. So I said, so your body cam was on at the time, and did you get any competent basis on the traffic stop as far as like a recording of that video?
I don't have a dash cam.
You don't have a dash cam in your car?
We don't have dash cams in Panama State Police cars.
It's cool. And I was failing to maintain the lane. Okay, was it any other traffic on the road?
You were the only vehicle.
Okay, and how long were you behind me before you actually pulled me over?
I was behind you about 2 blocks, watched you drift over the center line several times.
Several times, drift off the line. Did you have to catch up to me? You know, I have a dash cam and rear view cam. I'm probably gonna introduce the whatchamacallit. Did you actually have to catch up to my vehicle, or?
I did not have to catch up that much. I was right behind you.
I'm saying that the stretch of the road was we was traveling on Beach Drive. That's right.
Yes.
And you were behind me the entire stretch of Beach Drive?
No, I was behind you by Balboa.
By Balboa is when you got behind me. Okay, and so when did you notify me or the passenger about any of the drugs or gun?
Immediately.
Immediately? And what was said about the drugs or gun? What did the passenger say?
The gun was found after you were already detained. We searched the vehicle and it was underneath your seat.
Okay, and was the vehicle registered to me?
Vehicle was registered to your girlfriend.
Okay. And so where were the drugs or anything found in the vehicle?
You had drugs in your pocket. And there was also drugs in the back seat behind your seat.
And you found the drugs?
I found a bag of white substance in your right front pocket.
What about any vehicles in the car?
There was a bag in behind the driver's seat that had several other bags that were wrapped in a clear plastic baggies that was behind your seat.
Okay, and so what did you question the passenger on?
That would be my partners who questioned the passenger. I questioned you.
Yes, and what did I admit to any of the drugs?
You refused to talk to me other than saying I was violating the Treaty of Florida.
Exactly. And so you notified me on drugs being found in the car on the scene, you're saying?
Everything was notified to you. I tried reading you implied consent. You refused to actually listen to me. You kept on saying I was violating the Treaty of Florida and you.
Yeah, I was saying you was violating the constitutional rights as well of unreasonable search and seizure.
This cross-examination is a masterclass in why representing yourself is usually a terrible idea. The defendant asks questions that don't advance his argument, misunderstands procedure, and repeatedly circles back to points that don't legally matter. He believes he's exposing contradictions, but instead he's reinforcing probable cause. The officer remains calm, factual, and precise, while the defendant drifts between constitutional buzzwords and irrelevant details. Courts don't reward effort, they reward clarity and relevance. This is what happens when someone learns just enough law to feel empowered, but not enough to apply it correctly. Confidence without competence is dangerous, especially when your freedom is on the line.
Because I never really got a direct quote on why you actually stopped the vehicle.
His all in body came out.
Okay. And so you never had a conversation with the passenger.
I was mostly talking to you and searching the vehicle. I believe my sergeants wanted to talk to Mr. Wheeler.
Okay. And so you saying your passengers, your other one of your partners found the drugs that was actually in the car?
And I found drugs in the vehicle.
Oh, you found the drugs in the vehicle?
Yes.
Behind the driver's seat, you're saying?
And the objection. Ask your next question.
Okay. And you did already admit that I said I admitted to smoking hemp. Okay. And your vehicle is not you say they don't got dash cams. Okay. So at the time, did you have a sight on the passenger and the driver at the whole time?
I was right there behind the A pillar or B pillar.
What was that, sir?
I was there the entire time talking to you.
No, okay. So when you extracted me out the car, did you have eyes on the passenger at that time?
After I removed you from the car, I did not have eyes on the passenger, just you.
Okay, cool. And so in your report, you never wrote a ticket for the failing to maintain lanes, nor did you mention it in your affidavit of complaint.
It's going to be in my report, the narrative on the case.
Well, this was the probable cause, and this was the immediate review. So is it
Sustained. Ask a question.
okay? Is it a reason why you didn't mention it in your affidavit of complaint?
The affidavit only shows PC for why we arrested you. It doesn't state in there why I had to stop you. It just shows in there why I arrested you. And in regards to you maintaining a lane, that goes back to the DUI, which does not go on the complaint. That goes on the traffic ticket.
Well, you never mentioned anything of that nature in the ticket. So I was just wondering, is that protocol for you not to explain in the affidavit of complaint?
It's going to be in the report.
Okay, and you say you had a body camera on again, that's correct?
Sustain the objection. Ask your next question.
Okay, and so was it possible for any of the drugs to be the passenger?
It was all in your control. It was within your reach, behind your seat, and then you had drugs in your right front pocket.
I said, was it possible to be the passengers?
It could be possible, but the same drug that was in your right front pocket was also in that bag behind your seat.
What drug was in my right front pocket?
Cocaine.
And about how much was that?
You had a bag that was wrapped in your front pocket.
About how much?
I don't have the numbers on me right now. I have my report in front of me.
Okay. This is a copy of your report.
That's actually not my report. That's the affidavit complaint. My report's about 5 pages long.
Okay. And so you seized the vehicle for failing to maintain a lane. You said, was any other traffic affected by the occurrence?
You were the only one on the road. You had a failure to maintain your lane several times and you drove over the curb.
What curve, actually?
The curb I stopped you at, I believe it was on Fairland.
Okay. Beyond at this time, I don't have any more questions.
Okay. Does any redirect from the state?
No, Your Honor.
And the witness be excused.
Yes, Your Honor.
So you can go about your day.
Either.
Anything else from the state?
No, Your Honor.
Mr. Beecham?
Your Honor, there's no actual competent and substantial evidence in the affidavit of complaint, nor was it any ticket issued for the actual, failing to maintain a lane, so, being that it was immediately after the arrest, I don't see how he had probable cause to stop me. And I actually asked him for, the sheriffs to verify that, hoping that he had a dash cam in his car.
Mr. Sullivan?
Whether a traffic ticket was issued or not is irrelevant.
Yeah, it was.
I have them on find there's probable cause for the arrest, and I believe that's what I'm here today to do as far as the adversarial preliminary hearing. So I found there's probable cause. We'll need another court hearing.
Do we have this transcribed?
You can file a motion to have it transcribed, yes, sir. We need to set another hearing. You understand, Mr. Beecham, at any point in time that you ask for an attorney, one can be appointed to represent you if you meet the financial requirements. You want to set up for another pretrial? Beecham?
Yes,
Let's set it for April 18th at 9 o'clock.
At the end of the day, this case highlights a simple truth: the law doesn't bend for belief systems. Judge Brantley Clark demonstrates exactly what effective courtroom management looks like: firm boundaries, procedural fairness, and zero tolerance for nonsense. The rulings here weren't emotional, they were methodical. Probable cause was established, testimony held up under scrutiny, and the defendant was repeatedly reminded that legal representation was available, a reminder he ignored at his own risk. Every outcome we saw today was the direct result of choices made in real time. And that's the lesson. If you found this case as shocking, or as fascinating, as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns just like this one.